Good afternoon, students. Today is the day before the great day, the penultimate day. And I can feel the tension and also the adrenaline rising up and all that. But it's nothing for you to worry about. I have my learned friends and colleagues. I have Gertrude AMARH, University of Professional Studies, School of Law, UPSA, with us here. Gertrude, please, can you show your face? Can you switch on your video, if you don't mind? Can we? Yes. Great. Okay. So, welcome. And I have my friend and learned colleague also from KNUST School of Law. We're expecting 2 people from there. Dr. Samuel Bodia-Dakwa is supposed to join us, but is delayed by some emergencies he's attending to. We have Mr. AGYEI here. Mr. AGYEI, can you show your face? Let's see if it's then we have my friend, learned friend, Mr. Stanley TWENEBOAH KODUA. Stanley, can you show your face, Stanley? Okay, I think he will join us. Mr. Bill. Okay, so this is what we are going to do to enable as many people as possible to benefit from what we are doing. We are going to also stream live on the Facebook so that whoever wants to join us can actually join us. So that is how we are proceeding. Just a minute, we'll get the Facebook. Just a minute, we are connecting to Facebook Live. Okay, so this is what we are going to do. There's a few housekeeping rules. Okay, we have some of our colleagues. Okay, Samuel is here. Few housekeeping rules, and these are that this is a typical Q&A session, right? Questions and answers session. And this is what we want to happen, that if you have like a question, you raise up your hand and then we allow you to speak. We take 5 questions at a time. After we have finished discussing the 5 questions, then we take 5 more. That is how we are going to speak. So when the questions are taken, then I invite the panels to share their thoughts and we conclude on the question and move on. So when we've exhausted 5 questions, then we move on to other questions, okay? But just before we allow you to come in, I will take the preliminary remarks, opening remarks from my colleagues before we start. Now, as far as I am concerned, I'm being with you almost every day, so that all of you or most of you are very used to me, so I'll not have a lot to say by way of opening remarks. But as we get into the middle of the discussion, some few other thoughts will be shared on some recurrent issues that I receive from some of you. So I will yield to my colleague AMORKO, AMARH, to give us her opening statement before we take questions. And then I'll take some from my other colleagues, Mr. J, and then Mr. TWENEBOAH as well. We're expecting Ezekiel will say to any moment. Yes. Yes. Now, can we hear you?
Good afternoon once again, Dr. OWUSU-DAPAA, and good afternoon to my colleagues who have joined in this final preparation session. And of course, to all my, I trust and I believe strongly that you are all doing very well. It has been a very long journey by way of preparing for this entrance examination. But like I have always told you at every meeting or at every interaction that I have had with you, you need to have confidence in yourselves and in your abilities. I can understand the tension, I can understand the anxieties, but I have always maintained that it is absolutely essential for you to maintain your calm at all times. You have been having these preparation sessions with Dr. DAPAA for some months now. A few times I have been able to join, I have been able to listen to your views on matters relevant to the examination that you are going to write. And generally, I get a sense that you are doing your very best when it comes to the preparation. So by way of my preliminary comments, I would want to assure all of you, or rather to entreat all of you to continue to remain calm and to continue tomorrow when you sit behind your paper, and throughout the paper. There's nothing like last minute, so there's nothing much that you cannot do in these dying hours. For a law exam, you would all agree with me that even 30 minutes can make a lot of difference in your performance. So there's a lot that can happen between today and tomorrow. So for example, I wouldn't be surprised if there are some of you who are joining us here for the very first time. No need to worry at all, no need to panic. Still make the best out of the opportunity that is being presented to you this afternoon. Continue to take the revision seriously. Do not panic. Let us make the very best out of this session we are about to have. Whatever question you may have, whatever issue you may not be very clear about, feel free to raise it, so that Dr. DAPAA and his colleagues, myself and my colleagues, would be able to assist you if we can. So let us make the very best out of this session. Let us remain calm and confident in ourselves, knowing that we have put in a lot, and as a result, we are hopeful that we are going to write the exam tomorrow and come out full of smiles. So with that being said, I want to thank Dr. OWUSU-DAPAA once again, and I would also want to wish us all, or wish you all, the very best in the paper tomorrow. Thank you, Doc.
Right, thank you very much. Now, AMORKO, AMARH. I'm known in UPS as Gertrude AMARH for the very inspiring open words. So I have more of our colleagues joining us. So I noticed that Mr. AGYEI has joined us. Mr. AGYEI, can you start your video, if you don't mind? Then I also noticed that EZEKIEL is how to call a living testimony of hard work towards the law school entrance examination, because he wrote it exactly a year ago, and he passed, and he is finished the part one, so to speak. So I thought that I should bring him here, because he's also been my TA, the Kwame Nkrumah University of Science for quite some time. So I thought that his presence here will benefit the exercise. So we have them here. So I don't know if Mr. Bill, Ezekiel said, can you open your video if you don't mind so that we see you? Stanley, Mr. Stanley TWENEBOAH KODUA, can we see your video? Stanley? All right. So can you introduce yourself briefly and your few opening remarks before we move on? Mr. Stanley, it appears what you said could not be heard because your mic was off. Yeah, you have to switch on your mic. Oh, sure. Let me make you a co-host. Yeah, so I've made you a co-host. I think you should be able to unmute yourself. All panel members are made co-hosts.
Very well, sir. All right. Good afternoon, colleagues. I'm Stanley TWENEBOAH KODUA, an associate at OWUSU-DAPAA Law and Associates Limited. I joined the firm last year for my internship pupillage and subsequently as an associate. We've been through this same procedure. I wrote my exam in 2018. I was panicking, but I was advised not to panic. So the first advice I'll give all colleagues here, I've seen some of my colleagues, my LLB mates on. We pray that you do not panic. Don't panic. It's not as though, never have it in your mind that there are some traps deliberately erected in your path to prevent you from going to law school. If you have that idea, then sorry, you can't make it. Be positive about the exam tomorrow. And by the grace of God, you come out with flying colors. So last minute mop-ups like this are very, very beneficial. We hope that tomorrow, this last minute mop-up will yield beneficial interest to all of you. I wish you good luck and Godspeed in the exam tomorrow. Thank you very much.
All right, thank you very much, Mr. Jamfi. So we'd like to hear from my colleague, AGYEI, who is also colleague at the NUSC Faculty of Law. Yes.
Yes, thank you, Doc. Again, my name is AGYEI. Fortunately, I also sat for these exams, and I also went through it. In fact, usually around these times, many people may panic, but then my advice is that don't panic, right? Just give it your best shot. Yes, I've seen people saying that now the numbers, as in we are picking out only 550. Can be part of that number. Yes, so don't panic. Just give it your best shot. Go there, relax, and then give it your best shot. This one too shall pass. Yes, thank you.
All right, thank you, Mr. AGYEI. Yeah, so we'd like to hear from the most recent candidates who have gone through the law school examination. EZEKIEL OSEI from KNUSC Faculty of Law and an intern. Yes. EZEKIEL, switch on your video. Let's hear your opinion statement.
All right, so thank you, Doc, for the opportunity. I'm so grateful. So many of you may have known my name by now. I am EZEKIEL OSEI, and one of the successful candidates last year who sat for the entrance exams. I would say that being myself a student, even as it stands now, I believe that anytime any student hears that there is going to be an examination and there is just 24 hours for that examination to happen, there is that kind of fear, that kind of loss of confidence and all that. sometimes you look at the things that you've read and the things that you've not read, it sort of puts you on some sort of a shaking ground that, am I going to make it? I would say that the most important thing is to look into yourself. The examination, of course, is just going to cover some few aspects of the things that you have been taught in class. So believe in yourself that whatever that you've learned and whatever that you know, you are going to deliver. And don't let the numbers or anything that you will see there tomorrow. Of course, you will see a lot of people, and it's something that you cannot do anything about it. But you shouldn't let that one scare you. Just know that you've learned, and you believe that by the grace of God, you are going to excel in the examination that you are going to write tomorrow. So those are my few words for you. Yeah, thank you.
All right, thank you, Mr. EZEKIEL OSEI. Hearing from you as a very recent successful candidate who have gone through this examination, I think that it gives a lot of hope, because I started law school in 2001, so my story is not inspiring enough, but yours is definitely inspiring. Good. So having said that, my other colleagues are not here, but we'll continue and take the questions. So this is going to be the order of proceedings. I take 5 questions, then I invite the panel, we discuss them. After that, we take another 5, that's order, right? So if you want to speak, you raise up your hand, and then we will allow you to speak. You have to be quite snappy so that you can cover a lot of grounds. Good. So your questions are invited. Yeah, so we have Amita. Amita, let's hear you.
All right. Good afternoon, Doc.
Good afternoon.
Yes, please. I'll be very grateful if you could briefly touch on forced imprisonment.
Forced imprisonment. Okay, we've taken it to discuss it. Thank you. We need 4 more questions, and then we will continue. Yeah, we have just 4 more, then we deal with them. Okay, so let's take Bex. Bex.
Good afternoon, Doc.
Yes.
Please, I wanted to know how you'd be able to distinguish between a tort question under assault and battery, and then a criminal law question under assault and battery.
Tort question under assaults and battery. And then criminal law question. Okay. Good, thank you. So we need 3 more, and then we will invite the panelists to discuss. I'm excited that we're not getting a lot of hands being raised, meaning that the preparation is absolutely solid, right? It's a rock solid preparation, and every mountain of a question is submerged under the anointing of the mighty preparation that these students have made. No wonder we don't have their hands up. Very impressive. Good. Okay, so let's take the iPhone. iPhone guest, yes, please.
Hello, Doc.
Yes.
Sorry, my name is Ted. I had forwarded some questions from Wisconsin University in respect of.
Which platform, please?
On your private, WhatsApp, yes, please.
Okay.
How
long ago or just today?
This morning, it has to do with the simple question.
Can you forward it again? Because I have so many.
The unilateral is a contract. I'll forward it.
Yeah, all right. Yeah, forward it again to me, please. I have my phone. All right, so good. Okay, so I think we have one question from the chat. See you, a brief on constitutionalism, and then we have Ajua. Can you take us through the right to demonstrate, and when a fetter will be placed on that right? Okay. Right to demonstrate. Okay, so let's take the last one, then we'll discuss them. What is it? President, put your hands down. Okay. Okay, so Cecilia. Cecilia.
Hello.
Yes.
Good afternoon.
Good afternoon.
Please, I would like you to discuss on defamation, especially on the media. A brief discussion on that. Thank you.
My pleasure. Okay, so we will invite the panelists to discuss the questions which have come up so far. So we are starting from false imprisonment. So panelists, will say that let's discuss generally, not specifics, like, so false imprisonment, what is it? What should we look for when we are talking about false imprisonment? Lawyer Gertrude, you want to have a go?
Hello, Doc, can you hear me?
Yes, please.
Right, okay. So I'd want to believe the query is on false imprisonment generally as a tort.
Yes.
Yes, and then maybe we can also take the opportunity to look at some of the elements that must be present in that tort of false imprisonment. So when you look at the common law tort of false imprisonment, we are generally looking at an unlawful restraint, if you may, on an individual's personal liberty or the freedom of movement of an individual. But one thing you need to notice that for that act to constitute false imprisonment, it is not necessarily the case that an individual ought to have been assaulted or confined to a particular space. So generally for false imprisonment, we are looking at an unlawful restraint of someone's personal liberty. Now, once again, you need not prove that, for example, physical violence was used in restraining you into that particular space, such that you're from enjoying or benefiting from that right of your personal liberty. Now, you'd also want to ask yourself,
Well, Gertrude, are you there? Okay, I think Lawyer Gertrude's line has momentum. Okay, so let's invite other panel members. Mr. Bill.
Okay, Doc, I would want to take the constitutionalism question, the one on constitutionalism.
All right. Okay, then that's if anybody wants to add anything to false imprisonment, Mr. EZEKIEL, and then Mr. Jemfi.
All right, Doc, let me take it. Except to say that whenever the idea of false imprisonment comes, the locus classicus is Bird versus Jones. That we need not forget, and that the confinement to imprisonment must be total. Imprisonment is total. Imprisonment is the total restraint of the liberty of the person and not partial obstruction of his will, whatever the inconvenience it may bring. So we must have at the back of our minds Bird versus Jones. So as Lawyer Gertrude intimated, it's not about the force that was applied or whatever, whether or not force was applied. The most important thing is that the imprisonment is total, such that if there is a reasonable room for escape, then we cannot say that there was imprisonment. All right, Doc.
All right, thank you very much, Jemfi. EZEKIEL, some thoughts on false imprisonment?
Yes, sir. So I want to add the fact that, you know, when it comes to tort areas, the most fundamental thing that you must know is the tort in question and the various elements that you would have to establish. So to add up to what my seniors, Stanley and then lawyer Gertrude have already stated, I wish to say that the tort has just 3 elements. The first one being the fact that the action in question, which is the imprisonment, must be a direct act of the defendant, and also it must be an intentional act, which is the second element. And the last one, which Stanley mentioned, which is the total confinement and all that. So I believe that just like any other tort that you know, once we give the definition, see out the element and explain them in that particular regard, that is what I believe I could add to this particular tort of imprisonment. Yeah.
All right. Okay. Thank you, panelists. I don't know if lawyer Gertrude is back. I think she has internet challenges. Okay. So the other thing which I would like to draw your attention to is that is what they call like the relationship between the common law torts and fundamental human rights, right? Now, if you go to UK, for example, following the Human Rights Act of 1998 and all that, of course, over there they have many other legislation, so which have even shaped some of these common law torts. Now, here in Ghana, there are some, when we are talking about them, there are constitutional relevance as well, right? So the tort of forced imprisonment, yes, it is quintessential common law tort. Nevertheless, we have a human rights regime under our constitution, right? Chapter 5. We have like the right to personal liberty. We have also the right to freedom of movement. And all these 2 human rights are relevant. Unless, so for example, you have like a problem-based question, and what you see in that scenario suggests that it is the common law tort of, let's say, forced imprisonment, as we have discussed. That is fine, good. So you have to tell us the element as far in Bess and Jones and all the plethora of authorities. But since the question has not insisted that, advise us on the common law tort of forced imprisonment, and then the question would just have said that advise the person. You have to know that there are 2 causes of action. You have like the traditional common law cause of action of forced imprisonment, as we have seen, and at the same time, that which will constitute the forced imprisonment also has implications for human rights, for the personal liberty of the person, the freedom of movement, and the same facts which could support a successful action in the common law tort of forced imprisonment could also ground a human rights enforcement action with respect to personal liberty and freedom of movement, as it were, in appropriate circumstances. So I just wanted to bring that to your attention as well, so that you have what we call like a very holistic approach. All right. Okay, thank you. So we will invite Lawyer Bio to take the constitutionalism question. But I think before that, the participants are indicating that there's a feedback. So Lawyer Bio and TK, if you relocate or do something so that we don't get like the feedback into the class. Otherwise, it jams the quality of the sound. Thank you. Good. So we move on to question number 2, and that has to do with how to distinguish between the tort question of assault and battery from criminal law question of assault and battery. I mean, that was a question by Bex. So I will invite Ezekiel. You have a go.
All right. So, Doc, thank you very much. In my honest opinion, when you look at the principles that regulate, these areas of law, both in tort and as well as in criminal law, there isn't such much differences. In fact, when you read the provisions that have been provided under section the Criminal Offences Act 29, you will get to realize that when you relate it to even the common law authorities and all that, they speak to the same effect. But I wish to say that there's a difference between the treatment of battery as under tort, as well as the one under the criminal law. With the criminal law, we have what we call the general offense of assault. And then under the assault, we have various divisions. So there is an assault with the battery, assault without battery, and then imprisonment. So you must get that particular distinction. There is nothing like assault and battery under tort as a tort on its own, and then assault and battery as a tort as a criminal offense under the Criminal Offences Act. The Criminal Offences Act knows nothing like assault and battery. What it knows is assault with battery, which is one form of assault as an offense defined under the Act 29 when you look at the provisions on same. But as I said, the principles are virtually the same thing, because when you look at assault, we all know that basically we are talking about the fact that someone has introduced some sort of imminent threat of battery on your person and all that. The same definition is what the Criminal Offences Act seeks to provide for us. And the basic ingredient that an individual will have to show under tort in order to say that there has been the commission of an assault against his person is virtually the same thing that you have to establish as a prosecution when you are prosecuting the individual for assault in that particular regard. We must take account of also the fact that when it comes to assault and all those battery torts and then even the offenses and all that, one of the critical things that always will be some sort of a defense to relieve the individual of any liability, be it tort or criminal, is where there is consent. So over here, consent becomes something of the fact that if the individual in question has either expressly or implicitly consented to the act in question, then you cannot lay blame on the defendant for committing assault or committing battery on him. And this same principle is both for the tort aspect as well as the criminal law aspect when you are prosecuting an individual for the offense of assault created under the act. So basically, that is what I can say to that effect. Just know the distinction. The criminal law knows assault, and under the assault, we have three types: assault with battery, assault without battery, and then imprisonment. When you come to tort, we have battery as a tort on its own, assault as a tort on its own, enforced imprisonment as a tort on its own. But under criminal law, all of them have been classified under the general offense of what? Assault, with the necessary qualifications. So that is what I will say to this particular question.
Thank you, Mr. Ezekiel. We have now AMORKO Ama Gertrude back. Would you like to share some few thoughts? We lost you.
Yes, hello, Doc. Yes, sorry. I think I had a challenge with the network because I had a phone call coming in.
Yeah, sorry.
Now, just to add to what my colleague had earlier on said, I think it's also important for you to read and understand the facts as it is being presented to you very well before you decide on whether what is being required of you is to look at it from a criminal law perspective or from a law of tort perspective. I think this question is asked many times by students. Many of the torts that we know of can also equally ground an action under criminal law. So the question becomes, how do I know if I am expected to look at it from the perspective of torts or whether I'm supposed to look at it from the perspective of criminal law? Now, I think this is where your critical examination of the fact matter. Doc, I think I heard you when I came in, I heard you mention something. I'm not sure if you had already addressed that. The fact that we need to be very particular in reading and understanding the facts, because the fact would always give you an indication. Yes, it may be a very subtle indication, but the fact would always give you an indication of how to answer the question, or would give you an indication of what is actually required of you in your answer. So if you are given a set of facts that appear to be pointing towards the fact that someone was, for example, held in some confinement without his or her consent, or someone may have been assaulted, and you are not very sure whether this is something that comes under criminal law or that comes under the law of torts, the advice I would give is that pay critical attention to the fact as has been presented to you. There would always be certain alerts or certain indications pointing you towards one of these areas, which is actually what is required of you. So in addition to knowing the substantive law, also allow the facts to guide you towards a choosing of the appropriate area of law, which you need to look at the answer from. Thank you, Doc.
Right, thank you. Now, AMORKO, Ama, thank you very much. My other colleagues, I don't know if any of you would like to share some other thoughts, but further to what we have just been told, that we need to be very careful in reading the problem-based question, especially so where the same set of facts could ground an action in criminal law or some tort. Now, the advice I give, what we call like the desperate man approach, right? And that desperate man approach is this: where you find yourself, don't forget at this stage, I'm just advising you as a father and the children, just advising you that where it becomes really tough and you need some rules of thumb to help you to juggle around. Those are the kind of advice I'm trying to give on this particular occasion. That so the desperate man's approach is this: that you've read like the problem and you get a sense that this can actually give rise to certain thoughts, which you know. At the same time, it can also give rise to certain criminal law offenses. Now, because the exams you are doing, as I said, is a composite paper, like one paper straddling says law subjects, right? If you are not 100% sure that, let's say that this particular scenario, for example, is about the thought of battery assaults, and you also have the feeling that this can also give rise to, let's say, criminal law assault or something like that, I would say that do both, right? If you do both, you fall within the marking scheme. You will not be marked completely wrong. The examiner will just get a probably piece of that. Why are you trying to put like the two there? But at least if the question is properly about, let's say, like the thoughts aspect, you fall within. On the other hand, if you was also thinking of like the criminal offense and you also did that, you will not miss all the marks. So that is what I call like the desperate man approach, right? When you are caught between the devil and then the deep blue sea, and you need to actually work your way out and get some rescue. Okay, so we move on to, unless my colleagues have got some other things to say with respect to this particular question. I mean, okay, Mr. Bio, you have anything to say? Mr. Jemfi, do you have anything to say on this particular question, or we should move on?
Okay. Let's move on.
All right, good. Then we move on to the question by somebody called CEO, and he would like us to, I think, revisit the topic constitutionalism. I think that was a question. There was no specificity to that. He said that just clarified constitutionalism. So I think that constitutionalism, as we have explained time and again. Okay, Mr. Abil, you expressed particular preference for this. So let me give you the first shot before I come in. Mr. Abil.
Oh, okay, Doc, thank you. Basically, constitutionalism connotes the limited government. You know, per the famous quote by Lord Acton, he says that power corrupts, but absolute power corrupts absolutely. Thus, as of necessity, in order not for us to have a situation whereby an entity or a person wields so much power, there's a need for that particular entity to be restrained or controlled. So, yes, somewhere in 1960, we had a constitution, but then our constitution at the time didn't place the necessary checks to be able to limit our precedent. So the president at the time, he could hire and fire judges, he could hire and fire anyone at any time. That's by the structure of our current constitution. So we have some respective chapters governing how the various organs are to be structured. So for example, chapter 8 is on the executive, and then I think 10 and 9 also, 10 and 11 also for the other respective organs of government. So basically, it regulates how each organ of government is to perform its function, rather not to allow a particular organ or arm of government to wield so much power. So constitutionally basically suggests that the government must be limited. It must be checked. Yes. So, Doc, I don't know if
all right. Okay. All right.
Yeah.
Thank you, Mr. Bill. Yeah. So, rightly, the essential idea, as Mr. Bill has told us, is that constitutionalism connotes that there is absolute necessity to place restraints, right? To place restraint on those who wield governmental power. And of course, as he had already stated, that power corrupts and absolute power corrupts absolutely and all that. And these ideas, and Montesquieu and J. Boudin and so many other political thinkers have actually considered. So constitutionalism is not coterminous with having a constitution, right? Well, of course, having a constitution is a necessary ingredient for constitutionalism, but it's not sine qua non. If you have constitution, it doesn't guarantee constitutionalism, because as Professor Kumado has variously said in some of his writings, that constitutionalism actually is the ethos, right? The ethos, that is the sense of values, you know, among the citizenry, that there's a need to place restraints, to place brakes, right? To place brakes on the wheels of governance, those who wield power. And why do we do that? Because we know that for human beings, if a person is invested with power and there are no brakes, there are no restraints, there are no limitations, such a person is definitely going to abuse that power. And when that happens, it is the liberty of the citizenry that will suffer. And that is why constitutionalism is so crucial. So therefore, we know that constitutionalism may probably be one of three kinds. Substantive constitutionalism, in which those who are invested with power to govern are explicitly denying certain power, or explicitly, you can't do this or you can't do that. And we gave the example, let's say that Parliament has been given the legislative power, but there's a provision in the Constitution which says that Parliament shall not make a law turning Ghana into one party state, right? Parliament does not have the power to turn Ghana into one party state. So despite the fact that it has the power to make laws, the power to make law has actually been denied the ability to make laws, which will, for example, turn Ghana into one party state. So that, for example, is some sort of like a substantive limitation, right? Despite the fact that you have the power to make laws, you can't do this type of law, so to speak, as it were. And again, we also have what we call the institutional constitutionalism. Institutional constitutionalism, as we know that maybe one particular institution or one particular arm of government has been given certain competence, and it is only that institution that can do it and not any other institution, as it were. And of course, procedural constitutionalism, where you have been given the powers, but that powers cannot be exercised anyhow. The powers will have to be exercised in a particular way, so much so that if you choose not to exercise it in the prescribed manner, then you have actually not exercised the power properly. And that will be problematic. And that is why, let me just give you an example. If we take the Constitution of Ghana, for example, right? If we take Constitution of Ghana, for example, the supremacy clause of the Constitution, that the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers government are to be exercised in the manner and within the limits laid down in this Constitution. So in the manner and within the limits laid down in this constitution. So therefore, if you are the executive, right, and you represent the sovereign people of Ghana, so to speak, invested with executive authority, that cannot be exercised in vacuum. It will have to be exercised in a manner laid down in the constitution. And that is an example of procedural constitutionalism, procedural limitation. Okay, Ezekiel, you have some ideas to add, and then Mr. Jemfi and AMORKO, you have some few more words to add, please.
All right, Doc. I wanted to just add the various derivatives of the concept of constitutionalism,
right,
for the purposes of the examination, so that if you should get a question where it requires you to discuss constitutionalism, after doing the general discussion about the various types and everything, it is also important that you touch a bit on the derivatives of constitutionalism. And text writers, when you read the books, Abochi's book and other prominent constitutional law textbooks, you do realize that they are basically 4 derivatives of constitutionalism. The first one, which has to do with what you call the limitation of power. A limitation of power in the sense that here, the powers of the government or the organs of government are being limited either substantively or in terms of procedure. So in the substantive sense, as Dr. DAPAA rightly said, we are looking at certain things that the government can do and certain things that it cannot do. And a classical example of it is Article 3, Clause 1 of the Constitution, where we are told, for instance, that Parliament doesn't have the power to pass a law to make Ghana one party state, even though we know from Article 106 of the law-making powers of Parliament, as well as Article 93 and all that, where we are told that Parliament has set powers to make laws, but substantively, it cannot pass a law that will make Ghana one party state. Then you can also talk about the procedural limitation of powers. As Doctor said, that one has to do with procedure. Okay, so yes, the substance of the thing in question, you are allowed to do it by the Constitution, but the Constitution has provided the mechanism or the procedure by which you are supposed to do the particular thing in question. So clear example, you can mention Article 78, which gives the president the power to appoint ministers and all that. But such an appointment is subjected to parliamentary approval, which is a matter of procedure. Also, you can talk about the lawmaking powers of Parliament, that under Article 93, Clause 2, Parliament has such legislative power to pass laws and all that. But you realize that the procedure for passing of laws is regulated under Article 106 of the Constitution. Then we also have respect for fundamental human rights as one of the derivatives of the concept of constitutionalism. So we all know that in modern and then participatory democracy, we realize that the respect for fundamental human rights is very sacrosanct and then indispensable when it comes to responsible governance. In that light, we realize that government are being ensured that their individual rights, which are enshrined in their constitution, are being respected and upheld. That informs the reason why when you read Article 12, Clause 1 of the Constitution, you realize that they said that the fundamental human rights guaranteed under Chapter 5 should be respected by the executive, the legislature, and then the judiciary and all other government agencies and all that. Okay, so, and that also tells you why in the Constitution we have a lot of what you call the clawback clauses, which seek to limit enjoyment of rights. And even when government wants to take away rights of individuals, there are certain procedures that the government will have to follow. And a classic example is, for instance, Article 20, where it talks about compulsory acquisition of property. There are certain constitutional guidelines which has to be fulfilled before certain things can be done. All of them are just there to place a fetter on the powers that could be exercised by the government in question. Then the doctrine of separation of powers is also one of the derivatives of the concept of constitutionalism. So as we all know that when we are talking about separation of powers, you are looking at the fact that the 3 arms of government are independent with each other and all that. But I know that from your readings of the cases of Ghana Bar Association and Attorney General, you are aware of the famous rendition of GSC as it then was, as regards the fact that when it comes to the Ghanaian constitutional architecture, there isn't such complete separation of powers, and that there is a sense in the constitution of checks and balances and all that. So even though the 3 arms of government exist independently of each other, they nonetheless correlate and then they interdepend on each other. And you can make reference to Article 58, 93 to 125 plus 3 and all that as one of them. And then the last one is the what you call the power held in trust. Power held in trust starts from what Dr. DAPAA was trying to say about the fact that sovereignty resides in the people of Ghana when you look at Article 1, Clause 1 of the Constitution. And because the sovereignty resides in the people of Ghana and the government is just a representative of the people, it is also believed that whatever powers that the government is exercising in respect of the governance of the people has to be checked and has to be, they have to make an account for the powers that they are exercising. And that informs the reason why we have the actual popularis clause under Article 2, where if any act has been done by the government or any government agency, which is in violation with the basic law of the land, the Constitution 1992, you could go to the Supreme Court and seek for a declaration to that particular effect. So all these things, when you look at the derivative, you realize that in one way or the other, yes, the government has power to do something, but there are certain constitutional factors which have been placed on the powers of the government. So, Doc, this is what I wanted to add to the discussion. Thank you.
All right, thank you, Mr. EZEKIEL. Now, Gertrude, do you have anything to add, or we should? Yeah. Now, AMORKO, please. Anything? Your mic is switch off, so you have to unmute yourself. Your mic is switch off. Now, please check your mic. Okay, let me see. Yeah, please. Okay.
Yes. So I was just struggling to make the point that you had to unmute me. I was trying to unmute myself.
Oh, you are a co-host.
But
Okay.
the system said only the host.
Sorry.
No, Doc, I think on constitutionalism, that is fine. So if you could move on, please.
Very
I don't have anything to add.
Very well. But no, listen to Mr. EZEKIEL's contribution. One thing students will have to remember, the interrelationship, right, between the ideas of constitutionalism, separation of powers, rule of law, right? Of course, talking about separation of powers, we often mention what we call like the checks and balances as well. Actually, checks and balances and all those things are embedded in the ideas of constitutionalism as well. So I am very excited about the linkages which he drew, so that assuming, of course, at this stage, as I said, nobody is trying to play the prophets regarding what will come or what will not come. We are just exercising caution, just in case you have an invitation to, let's say, discuss constitutionalism. You have to appreciate that the whole terrain of constitutional law, especially the fundamental concepts or the doctrines of constitutionalism, separation of powers, checks and balances, rule of law, right? They all work hand in hand, and you should be able to pull them together beautifully to generate whatever essay that you are invited to do. So that is what I just wanted to remind you. Okay, now having said that, we still have another question from Ajua. The right to demonstrate, and what are factors on the right to demonstrate? I think because of what is going on in the country, a lot of our students are affiliated by the law on the demonstration. So, panelists, Mr. Jamfi, and then Mr. Bio, EZEKIEL, and now AMORKO. Yes, what are your thoughts? Mr. Jamfi, Stanley Jamfi. Is Stanley there? Yes, Stanley. Yes, what are your thoughts on the right to demonstrate and any factors or limitations on that right? And one of our students is interested in knowing that. You can mute yourself, please. I think it's Stanley there. Yeah.
Doc.
Yes. Okay, Ezekiel. Right.
Okay, let me try and say something small about this one. So I believe that we all know the fact that the right to demonstrate could be subsumed within one of the fundamental freedoms guaranteed under Article 21, Clause 1D, which talks about the freedom of assembly, including freedom to take part in processions as well as demonstrations. Yes, in as much as this is a right, we all know that they are not absolute right, in the sense that there are constitutional factors to this right that you may exercise. I always say that when you, even before you come and read some of these fundamental human rights, right from the beginning of the Constitution, that is chapter 5 of the Constitution, you are told under Article 12, Clause 2 of the Constitution about the various constitutional subjectivities of the rights which have been guaranteed under chapter 5 of the Constitution. So if you have your Constitution, just turn to chapter 5, Article 12, Clause 2. And if I'm to quote, it says that every person in Ghana, whatever his race, place of origin, political opinion, color, religion, creed, gender, shall be entitled to the fundamental human rights and freedom of the individual contained in this chapter, but subject to the respect for the rights and freedoms of others and for public interest. So right from Article 12, Clause 2, the Constitution has given you two broad fundamental restrictions on your enjoyment of any of the rights in this Constitution, including the freedom to demonstrate. So I will say that, yes, your freedom to demonstrate, yes, even though it has been guaranteed in the Constitution, first of all, is also subject to the enjoyment of rights of other individuals. Said that if in a situation whereby you are going to exercise this particular right, you are likely to hamper or impede the enjoyment of the right of other individuals, then such a right, even though guaranteed, will be restricted, or you'll be prevented from exercising that particular right. More likely to, we are talking about public interest, and we all know that when we talk about public interest, we are looking at something to the benefit of the public as a whole, or something to the advantage of the public. For instance, you have a situation whereby if you should go on this demonstration, we are going to cause a danger to, let's say, the lives of the people, cause destruction to properties and all that. Like you are going to cause chaos, said that you wouldn't be able to conduct the demonstration peacefully. Then in that case also, your right to demonstrate could be what? Restricted. And even Article 21 itself, Article 21, Clause 4, when you read it, you realize that there are also other considerations which are more or less, like I believe that they explicate the two fundamental constitutional restrictions provided for under Article 12, Clause 2. So when you go to Article 21, Clause 4, it gives you a number of things, or a number of restrictions on all the fundamental freedoms that have been guaranteed under Article 21, Clause 1 of the Constitution. And when you read, you realize that there is the public health, there is, what do you call it, the defense of the state, there's public safety. All of these go into placing a fetter on the enjoyment of the individual right or individual freedoms guaranteed in the Constitution. And I believe that is the reason why Parliament even has in place the Public Order Act, where it mandates individuals who want to go on demonstration to seek the consent of the police and all that before they can embark on this right of demonstration and all that. So I believe that if in examination you don't have anything at all, you don't know what do you call it, the details of even the Public Order Act and all that, just know right from the Constitution the fact that every right guaranteed in there, the enjoyment of it is subjected to the enjoyment of another person's right, public interest, among other things. And I believe that is how you should do the discussion. You may also want to take solace from the dictum of Emosechi in the famous case that I believe all of you know by now. That is the MPP and IGP and Attorney General. If you read the dictum, I'll indulge you to go and read that case. If you read the dictum, the learned justice as he then was took his time to expand the law on the freedom and even the liberties and how it relates to other fundamental human rights in the Chapter 5 of the Constitution. So look at it and look at the exceptions to it, to that particular effect. Yes. So that is what I would.
Okay. Thank you very much, Mr. Ezekiel OSEI. Yeah, so further to that, one thing that we should keep in mind is that there is nothing like absolute human rights, right? We have fundamental human rights and freedom, but there's nothing like absolute. When we say that absolute, that is to say that to have a situation in which the human rights of a person, what the person is demanding, will always stand, regardless of the rights of others. And we must always have recourse to Article 41. I don't know if Mr. Ezekiel mentioned that Article 41 is very important, the duties of a citizen. And if you look at Article 41, paragraph D, for example, that the exercise and enjoyment of rights and freedom is inseparable from performance of duties and obligations. Accordingly, it shall be the duty of every citizen to respect the rights, freedoms, and legitimate interests of others, and generally to refrain from doing acts detrimental to the welfare of other persons. So Article 41, which enjoins us to observe certain duties, presupposes that even quite apart from the general limitation, which we see in Article 21 of the Constitution and all that, we are always supposed to enjoy our human rights in such a way that it will not undermine the welfare and well-being of others. And that is why somebody will say that your right ends as another person's nose. And that cliche is really true, and it's reflected vigorously in our Constitution. So to sum up, there's what they call like a balancing act, right? Balancing act in the sense that if we are talking about like the right to demonstrate, right? The right to demonstrate, which is also related to freedom of expression, because these two, they go together. You also have to make sure that other people's welfare are also not going to be affected. And that is why you don't need permission of the police to go on demonstration in Ghana. And that is the effect of the public order case. That is NPP against the IGP and the Attorney General. However, you know, the Public Order Act of 1994 requires that you must get what you call the PROW. You must have what you call the PROW notification. PROW notification simply means that you should notify the police, and it just for purposes of logistical arrangement, so that the police can put in place the necessary measures to provide protection to the demonstrators, so as not to let it affect law and order. And that is all. But the right to demonstrate is not given by the police, as it were. Good. So I think that we've said enough for that particular question, unless my colleagues would like to add more. Otherwise, we'll move on to another question. So let me find out. Mr. Bio, do you want to add more to this, the right to demonstrate question and then the fetus?
Oh, no, Dr. Ezekiel itself have done justice.
Right.
That question.
All right. Right, Stanley. Mr. Jamfi, can you? All right. I think I don't see him. Okay.
Hello, Doc.
Yes.
I have a problem with my connection.
You have. Oh, right. But you have. You want to say more words, or you should move on?
Doc, let's move on. I'll join.
Right. You can join. You can join your colleague, Mr. B. Right. Good. Now AMORKO Ama.
Hello, Doc. I'm here. Yes. I'm just looking at a question that someone, one of our friends has just posted. Why then do the police, the question actually says they, but I believe our friend is referring to the police, that why then do they sometimes seek for an injunction to stop the demonstrators? And I think the response to that is quite well established, because many a times when the police come out to try to stop, not necessarily stop, but try to advise the demonstrators not to go on that demonstration, there are a number of reasons they could cite. Doc, you remember making the point that the requirements for prior notification as established in the MPP and IGP case is mainly as a result of logistical challenges. So for example, if the police are of the view that looking at the number of demonstrators who are going on that demonstration, they don't have the logistics to handle them at that point in time or to give them the needed protection, then they may want to seek an ex parte injunction to what? Restrain them from proceeding on that injunction. I mean, sorry, from proceeding on that demonstration. And then I see my friend follow up to say that, is that not subject to abuse? Of course, remember the Supreme Court's pronouncements in the very recent matter concerning the, what is the name of the group?
What is the discipline? What is the
the most recent movement?
That fix no?
Fix the country, exactly. The fix the country. Thank you. Yeah. So yes, it is possible. That possibility of abuse is there, but that is why the courts, in my opinion, ultimately would have the right to either, you know, prevent that by, for example, setting aside whatever orders may have been made by a lower court in ensuring that that requirement of notifying the police is not abused by the police, by, you know, indiscriminately preventing demonstrators from exercising their fundamental human rights, although we have also just agreed that that right is not absolute.
Oh, right.
Doc, there are some more follow-up questions on that. I don't know. On that, so I see a question that is the needed protection from the police a legal requirement? So our friend is essentially asking.
Right. Yes. Now, well, okay, right. Thank you. So you see, one thing you should remember, please, don't let us have what we call the leftist or the extremist approach to, you know, human rights. So if you don't have the right appreciation, you can also end up becoming fundamentalist, as it were, right? Let's look at the practical scenario. Let's take Accra, for example, right? Let's say we have about 50 different groups, and all of them are desirous of demonstrating on the same day, and even probably around like the same area, geographical area. And let's suppose that you don't have the police there to ensure that there will not be clashes and confrontation between the various groups and all that. There's going to be chaos, and society may descend back to what Thomas Hobbes and John Locke and others will call like the state of nature, isn't it? So the police being notified so that the police will provide guidance so as to avoid public disorder is not in any way detrimental to human rights. It's rather enhancing enjoyment of the human rights. Just imagine you embark on demonstration and you ended up getting seriously wounded, or you ended up dying. Would you like to see enjoyment of your right to demonstrate to end up in your death or being injured due to the fact that the police or the law enforcement agencies were not around to ensure that other people do not attack you or you don't attack other people? So we have to approach it from that perspective. And I want us to reason as law students, please. All of us, in one way or the other, we have our political biases. But when it comes to law, I'm not NPP, I'm not NDC. I am quintessentially lawyer, first and foremost a lawyer, and I reason as a lawyer. And as a law student, you have to do the same thing. Forget about whether you support the physics country, you don't support the physics, that's not important. After your exams, you can go and do that. But let's reason as students of the law, okay? So if you are reasoning as students of, and that is why under the Public Order of 1994, which says that you should get a prior notice, give the police prior notification so that the police can arrange and provide. Now, if according to the police own arrangement, let's say that you want to have a demonstration at the Independence Square, and other two groups have already been, they have already notified the police that they're going to demonstrate over there. Now, if the police with the view that if you are also allowed to demonstrate there, it's going to result in confrontation. And let's say that they don't have enough men and they don't have enough logistics to create the requisite barrier, they can go to court and ask the court to place an injunction on you. So probably, if you are afraid of our abuse, then I would say that the injunction should not be ex parte. The injunction should always be on notice. That much I agree with you, so that those who intend to demonstrate and the police, they will appear before the judge, and then they put their positions, right? The grounds and the position they have to affidavit before the judge, for the judge to have a holistic view of whether the injunction should be granted or should not be granted. So that one I agree. If you are saying that the ex parte injunction by the police can be quite detrimental, that one you have a point. But if you think that it's not necessary for the police at all to provide protection for those who want to demonstrate, then I think that we are missing the point. Yeah, so that is what I would say on that. I think with Lawyer Gertrude, I think we have overflung this issue. We have to move on to another thing. What do you think?
Yes. I think we can go on subject.
Okay, good. Now, let's take the question by Cecilia. Cecilia's question is about defamation. So taking us to the law of tort. And I would like Lawyer Gertrude to come in with the defamation. Okay. Yeah, and yes. After that, I have Mr. BO2 here who has particular interest in, but that will be the next set of questions. So you, like Gertrude, let's go on with the defamation.
Okay, thank you, Doc. I can't recall exactly what the question was, but I recall one of our friends asking.
And then the question wants defamation and then the media, right? And then the media and defamation. Yeah, that was the question.
Okay. Well, that's fine. So I think I'll come to the media subsequently in my response to that. So yeah, I mean, we've been taken back to the law of torts on the issue of defamation. What is defamation? There are quite a number of legal authorities that provide for a meaning of defamation. But at a minimum, I mean, we can say that defamation is the publication of maybe an untrue statement which reflects on a person's reputation and which actually tends to lower that reputation in the estimation of right-thinking members of society. There are also other understandings of defamation, for example, that of Lord Atkin, that a statement which tends to lower the claimant in the estimation of right-thinking members of society generally, and in particular to cause him to be regarded with feelings of hatred, contempt, ridicule, fear, and disesteem. These are all statements or publication that could give rise to an action in defamation. But of course, being a tort, we would know that there are certain elements that must be established before we can say that an action in defamation has been established. But even before that, whenever we talk of defamation, the most popular or the most known types that we always refer to are libel and slander. So libel usually taking the form of a permanent publication. So either something that is in writing, or maybe in the form of a photograph, or an edifice, or what have you. Whereas slander is normally by way of oral statements, which are made with the intention of reducing the reputation of the claimant in the estimation of right-thinking members of society. So we can typically distinguish between libel and then slander. Now, one other thing we may want to remember is that whereas under common law tries to protect an individual's reputation by way of this tort of defamation, under customary law will not only protect your reputation, but would also protect your injured feelings. So it appears the ambit of defamation under customary law is much more broader. Of course, you'd all remember the very interesting case of Winchua and Redua, and exactly, and all those others. So it is not enough for you to say that, this statement does not necessarily lower my reputation or your reputation in the minds of right-thinking members of society. But does it hurt my feelings? Does it make me feel bad? Does it make me feel terrible, like a bad person, insulted, and so on and so forth? So with that, what then are the elements of defamation that must be established for an action in defamation to be successfully be said to have been established? So of course, first of all, as a claimant or as a plaintiff, you have to be able to establish that the words used or the publication that was made, they are what? Defamatory. When we say that they are defamatory, what do we mean? They must be those kinds of words, or it must be the kind of publication which, you know, like we have said severally, lowers the plaintiff's esteem before right-thinking members of society, or tends to ridicule him before right-thinking members of society. The other element is what we loosely refer to as reference. So by reference, we are simply saying that you as a claimant, you must be able to establish that those words or the statement or the publication, it was in reference to you and not any other person. So for example, if we are in a group like we are now, and you are of the view that I have said something to the group, but you think that that statement that I made is with particular reference to you, you need to be able to establish that before you can ground an action in defamation. So the reference is also very, very important. Then you must be able to establish that the words or the statement or even gestures, it could even be a gesture. So I sit back and then I use some sort of sign language, or I do some form of gesture, which could also be seen to be defamatory. So you must be able to establish that those words were actually published. So the requirement of publication is also very, very, very important. When we talk of publication, it is not, we are not saying that that statement should have been published to you. Publication essentially means that the statement was made to another person aside from you. So publication essentially means that the statement or the gesture was published because it was made to another person or to a group of persons other than you, the person who is directly claiming to have been affected by that publication. I think once you have been able to establish these elements, then of course, on the totality of the evidence, you may be able to say that, or the court will come to a conclusion that you have been defamed. But what about the claimant? No, what about the defendant? Can the defendant also have certain defenses to defamation? So can the defendant say, for example, that yes, I may have published that statement, but I had a defense. So the question essentially becomes, what are the defenses that we have to defamation? Number one, truth. If the defendant can establish that, look, the statement that I made was the truth and nothing but the truth. So I may have said something which was defamatory, but it is the truth. That is an absolute defense to what? Defamation. That is one of the defenses that we have to an action in defamation. Then we can also look at the concept of absolute privilege and then qualified privilege. You know, when we talk of absolute privilege, you realize that there are certain types of communications that are absolutely privileged. So absolute privilege in the sense that the person making that statement at a particular point in time and on a particular platform has the right to do so, even if ordinarily the statement would have been defamatory. Once that statement is being made by a particular person within a particular context, and sometimes even at a particular time, we can say that that statement is what? Privileged or enjoys absolute privilege. For example, statements made during judicial proceedings. So I am a witness in a court of law, and I make a certain statement while giving my testimony. That, for example, could be seen as an example of what? Absolute privilege. Of course, you also know that certain statements made by legislators or by members of parliament in parliament are also what? Subject to absolute privilege. Then we can also look at qualified privilege, like the name suggests. This is also a statement I would enjoy some form of privilege, but this type of privilege is what? Qualified. It's not absolute, like what we had earlier on looked at. So with absolute privilege, yes, the statement or the person making that alleged defamatory statement may have had the right to make that statement. However, if that statement was made, let's say, with malice or recklessly, or with some hate or with some spite, then would say that that statement would not qualify as having enjoyed absolute privilege, but rather would qualified privilege. I think we can also look at the statement, the defense of fair comment, and which, in my opinion, is one of the defenses that applies even more to our friends in the media. What do we mean by fair comment? At common law, when you talk of the common law defense of fair comment, you are essentially saying that there are certain matters that are in the public interest, and as a result of that, people, the media, whoever, should be able to express an opinion on that matter, especially because that matter is a matter of public interest. So long as that statement was not made with any ill will or with any malice or with any hatred to the plaintiff. So with fair comment, you're essentially saying that, yes, I may have made that statement, which is being seen by the claimant to be defamatory, but in actual fact, it is a matter of public interest. And as a member of the media, or even as an individual, I have every right, or I'm actually allowed to make that statement as a matter of fair comment. So, I mean, in recent times, we've had a number of cases on defamation. When you look at the cases of maybe Esankuma and Kevin Taylor, or even that of Abdul Malik Kwekubakun and Kennedy Ohine Japan. So the point is that for defamation, you need to be able to, first of all, establish the elements that are required to be able to ground an action in defamation. While doing so, you should also be finding out whether the defendant may have some justification or may have some defense for those statements that he or she made. Doc, are you there? May I end it here and then call up another friend?
Yes. Thank you very much. Now, AMORKO, I mean, this is a very extensive treatment of the subject within a very short period of time. Yes, so I will invite our colleagues to add a few words before we move on to the next question. Mr. Jamfi, you have anything to add? Mr. Jamfi is okay. Now,
and Doc, while we do that, please look at a question one of our friends has just asked.
Okay, Mr. Bio. Mr. Bio.
Hello, Doc.
Yeah, you have anything to add?
No, not on this one, please.
Okay. Mr. EZEKIEL say. EZEKIEL.
No, sir. No, sir. Up to this point, nothing.
Yeah, so like I get to attend the question. Please, do we have any constitutional provision on defamation in the 1992 Constitution? Of course. Yes. Yes, somebody has also even told you that you have like the right to the right to dignity, and has cited Article 12. I think what we should remember, and Lawyer Gertrude emphasized it, and I must even say that every tort, right, we have to ask ourselves, what interests is being protected by that tort? I think that should be the approach, right? What interest is being protected by that particular tort? So if you take the tort of defamation, what is the focus? Like, in other words, what interest is being protected? What is the purpose of that tort? So defamation protects your reputation, right? It protects your reputation within the minds of right-thinking members of what? Of society. And that is why the Cassidy case and so many other authorities will let you know that the test as whether your reputation has been injured unjustly or unfairly is essentially one of objective. And that is why I say like the right thinking members of the society. Yeah, so certainly, so long as it's your reputation which is being protected, the Constitution recognizes your right to personal dignity. And your right to personal dignity, what does it entail? Your right to personal dignity also encapsulates your right to have your good reputation and maintain, to have your image or reputation not soiled by unjustified and unwarranted statements. published to third parties. Yeah, so certainly the Constitution is very much interested in defamation. You don't have to see the word defamation, right? You don't have to see like the word defamation in the Constitution before you'll be convinced that the Constitution is actually protecting or is providing something on defamation. As I said, what is important is for us to ask ourselves, what interest is being protected by the tort of defamation? So once you have that, yeah, so now the Bureau has cited Article 12, that's the general protection, Article 21, the general freedom. Article 1 says to, that is the media, the press freedom, and then the 1 says for, yes. Yeah, so I think now I don't know if you want to add a few words to that particular question. Now, Mokoma, are you there, please?
Doc, I am. No, I agree perfectly well with you. I don't have any.
Right. Then we move on to, we've exhausted the first 5 questions. We are taking our next 5 questions. But then I noticed that some of the questions, we have one already. There's one question on the Commissioner of Inquiry. And then there's also a question on the outside clauses. So let's say that, so let me just take, so let's take from the chat, and then I'll come to Sung, Piaita, and then Daniel. Just in a second, I'll just release you to. So we have the question on Commission of Inquiry, the legal effect of the findings and recommendation of Commission of Inquiry. And then somebody is also asking a question on the whether in an AREC situation, it's advisable to analyze the rules together or one after the other. Okay, we'll talk about that pretty soon. So we have, let's say, 3 questions. So let's allow Sung Pieta to come in, and then we'll take the questions. Sung, and then Daniel later on. Yes.
Okay, thank you very much, sir. Doc, thank you very much.
Okay.
One of the speakers mentioned Article 1.1 that deals with sovereignty lying in the people and is exercised on behalf of the people. Now, we also spoke about these fix the country people, and they're calling for a new constitution and as one of their demands. So does that mean that if there's a clarion call by the people of Ghana, since sovereignty emanates from them, that this constitution should be done away with, it can be done away with without regard to the constitutional provisions as to how maybe amendments and all of, can the constitution be totally done away with without regard to that? And would that amount to maybe an overthrow of the constitution, and what are the implications? Thank you.
All right, thank you very much, Sung. Now let's take, yeah, I think that's, okay, now let's discuss that. We have so many other questions over there. So maybe panelists, let's start with the Sung Piata's question. And Daniel, hold on, we allow you. Let's exhaust the questions we have there. We come back to you and Tommy. So Sung Piata's question provide a significant amount of the answers needed for that question in the question. Because he is saying that the Face the Country people are asking for replacement of the current constitution, that we should throw away this constitution and adopt completely new constitution. And he wants to find out whether that is permissible, and especially so when we have a whole procedure for amendments of the constitution. And he wants to also find out whether what they are asking for does not actually constitute an attempt to overthrow the constitution as it were, especially having regard to Article 3 of the constitution. Well, that is a very interesting question. Now, just a quick one, and then my colleagues will come in. one thing we should remember is that the 1992 Constitution has provided a mechanism for reinventing itself to meet the exigencies of modernity or changing times. So there's a mechanism for the Constitution to reinvent itself, that is to update itself, should that become necessary. And that is why we have a whole chapter, chapter 25, the Constitution, on amendments, right, of the Constitution. And if you look at chapter 25, we have like the entrenched clause, non-entrenched clause, and so on, and how the various parts of the Constitution, depending upon how it is categorized or classified, should be amended. So therefore, if you are asking for replacement of the Constitution, if you could achieve that through the amendment procedures under chapter 25, then there's no problem. On the other hand, if you are not thinking of getting the Constitution changed through chapter 25 route, then what you are doing, you are asking for something which is never contemplated by the Constitution. And it will not be far from right if we interpreted what you're doing as a treason, because you are trying to overthrow the Constitution, as explained under Article 3 of the Constitution, as it were. Because if you remember, Article 3 clause 3 says that a person who by himself or in concert with others by any violent or other unlawful means, and that, so here I'm not so much interested in the violence, because face the country, let's give them the benefit of the doubt that they're not using any violent means, so we are not going there. But unlawful means, that is where my emphasis is, unlawful. Unlawful means in the sense that if you look at chapter 25 of the Constitution, right, which provides the mechanism for amendment. Now, what they're asking for, if it cannot be subsumed under the amendment procedure, either under Article 289, 290, 291, 292, as it were, then any quest for replacement of the Constitution is asking for the Constitution to be overthrown or abrogated by unlawful means, and that will be treason. So that is, then the initial thoughts I have with respect to that, but I will allow my colleagues to come in. So I don't know, Mr. Jamfi, are you there? Okay, we don't have him. Let's take lawyer. Now AMORKO, please, are you there? Lawyer Gertrude, are you there? You are missing. Okay, then let's take Mr. Bill. Mr. Bill. Is
Yes,
Mr. Bill?
Doc.
Yes.
So, yes, I'm here.
Yes.
I subscribe to your thoughts in that all other procedures apart from those proffered for under chapter 5, sorry, under chapter 25 of our Constitution, and then those provisions within 289, 290, 291, and then 292. Any procedure outside of these extra provisions may amount to an attempt to subvert the Constitution, because even going by Kelson's thoughts that the ground norm is the norm for which all other norms derive their validity. So if our Constitution being the ground norm proffers for how the Constitution is to be amended, and you sidestep the extra provisions in it, any attempt to do away with all these processes may amount to a subversion of the Constitution. So look, I'm inclined to support the position you proffered.
Okay, all right, thank you. Mr. Ezekiel said you had some thoughts.
All right, so thank you, Doc. Actually, this is a question that somebody asked me this morning about how if the request by the Fix the Country group that they should change the Constitution, whether it is right and all that. Yes, I think I substantially came from an angle that you came from. Just that I was I told the person, let me say what I said. I told the person that if in the Constitution, looking at the preamble and also Article 1 Clause 1, we are told that the Constitution was birthed as a result of the sovereignty which resides in the people of Ghana, then, in my view, the very people or the same people who
Ezekiel, are you there? Hello?
Hello, Doc, can you hear me?
Yes, Ezekiel, I can hear you. Please go ahead.
Okay. So I was making the point that if you look at the preamble to the Constitution and Article 1 Clause 1, we are being informed that sovereignty resides in the people. And we look at the preamble to, you were told that we, the people of Ghana, exercising our inalienable right and all that. So that sort of give a sense of the fact that the Constitution as we have now was birthed out of the sovereignty which resides in the people of Ghana. So my answer to the individual this morning was the fact that if the Constitution recognizes our sovereignty, okay, or recognize the fact that its existence came as a result of we exercising our sovereignty, then it means that if the people of Ghana at any point in time feel that the need has come for us to have a change of the Constitution, then they can do that. However, as you rightly said, they will have to do that through the proper procedural means that have been laid out by the Constitution or any other legislation that may be to that effect. And I even mentioned to the individual that yes, you would have to look at the requirement of Article 289, 290, and then 291 in order to change the Constitution. But then the mere fact that they are requesting for a change of the Constitution, as per the question the individual asked me this morning, does not in itself, in my view, does not amount to some sort of subversion. Because to do that, in my view, will be more or less like being too literalistic in terms of interpreting the provision in Article 3, Clause 2 of the Constitution. I believe that if we are to be guided by the famous dictum of Sowe JSC, as it then was in the 24 versus Attorney General, as we all know, 1980 Ghana Law Report, page 637, you will realize that he will let you know that the Constitution is the outpouring of the spirit of the people. It mirrors their beliefs, will, and traditions and values and everything and all that. So if we are being guided by that one, then it means the mere fact that the individuals who, by their sovereignty, the Constitution came into force, are now requesting that there should be a change in the Constitution. That, in my view, wouldn't what do you call it, amount to a subversion or a treason in the light of Article 3.2. The only instance I think that we should construe it to amount to a subversion or a change is whereby they seem to take any positive act, which act will lead to the overthrow of the Constitution without going through the proper constitutional mechanisms laid down under Chapter 25 of the Constitution. But the mere request, I don't think that one will amount to a subversion of the Constitution, in my view. Yes, sir. So that's what I will have to say, Dr.
All right. Thank you, Mr. Ezekiel saying. Yeah, I think that regarding characterization of the actions of the first country, I think we can have a very respectable differentiation of opinion. Because if, for example, you are asking people using various type of language and all that to undermine confidence in the constitutional establishment and pushing people to, let's have the Constitution jettisoned when same is not contemplated by the Chapter 25, which is a mechanism for amending the Constitution one way or the other. I think that it could generate some consequences which should not be seen as being legally neutral, and there could be some liability. But as I said, that these are areas that we can't have a settled opinion until there's been authoritative pronouncement by, let's say, the Supreme Court or maybe another court, as it were. Okay, so we will move on unless lawyer now AMORKO, please. Oh, I think we've lost her. Then we move on to the next question. I think the other questions which we have, it has to do with the Commission of Inquiry. So Commission of Inquiry, please, can we take it? Mr. Bill, Commission of Inquiry, the legal effect of findings of Commission of Inquiry and all that. And yes.
Okay, Doc, thank you. So with Commission of Inquiries, usually these commissions are independent and impartial, and then impartial commissions usually set up by the president to look into any matters of public interest. What amounts to public interest is very broad. However, per the provision in Article 295, touching on what amounts to public interest, basically it suggests anything that is advantageous or that inures to the benefit of Ghana. So same was restated in the case of Republic versus EZEKIEL Avalifo. So the question was that monies belonging to NDC, I mean, that the stealing of monies belonging to NDC amount to anything that concerns the public at large? The answer given by the court was that yes, once NDC's policy documents stands to govern the country at some point, anything that concerns them is also a matter of public interest. That's what affects them also affects the country at large. So we say amounts to a matter of public interest. Now, with regards to commissions of inquiry, it can be set up under Article 278. So where the president is either satisfied, or where Council of State advises, or where Parliament requests, the president can set up a commission of inquiry to inquire into any matter of public interest. Again, in the creation of regions, so not too long ago, some regions were created. The OT region, Northwest, Northeast, Savannah, and then all the other regions. A commission of inquiry was set up to go around the country, and the views were collated, and then the president was advised on the same, and then he duly set up or created these new regions. So in the creation, merger, or alteration of regions, a commission of inquiry is key in this process. So in the case of Professor Koko Asari and then Attorney General, the courts per Akamba GSC tried to categorize commission of inquiries. The first category was that some commissions are research commissions. They are research commissions, and then others too are investigative commissions. So for the research commissions, usually they are set up basically to go and then find facts and then advise the government on how to embark on a particular thing. But with the investigative commissions, usually there must have been an upheaval for which these commissions are established. And then at the end of the day, based on the reports, the president will take further steps. So, for example, the World Cup 2014 fiasco, and the Ayawaso issue, and then all those matters, they all suffice. Those commissions that were set up, they suffice as investigative commissions. Now, who can chair or preside over a commission of inquiry? Usually, they appoint justices of the Superior Court, or persons qualified to be appointed as justice of the Superior Court, or a person who has at some point held office as justice of the Superior Court, or a person possessing some special qualities. Usually, these persons usually preside over these commission of inquiries. So it can be presided over by a sole commissioner or a chairperson, and then other commissioners. Usually, when they are set up, the exercise powers are king of the high courts. By saying this, it doesn't mean that they are courts properly so-called. So they exercise quasi-judicial powers. They exercise quasi-judicial powers. So they can examine witnesses on oath. They can issue commissions for persons to be examined abroad. They can also cause for documents to be submitted before them. Yes. So once someone also asked the question that can a commission of inquiry also exercise or deploy the powers of contempt? The question is clearly no, because per the wording of Article 126, Clause 2, is the effect that the Superior Court shall be a court of record and they shall have the power to call for contempt unto themselves. So yes, they are being chaired by justices of the Superior Courts, but then when they sit over there, they only sit as commissioners and not as justices of the Superior Court. So they can't deploy the powers of contempt there. Yes, so let's note that. And then once a commission finishes its work, and then it comes up with its report, one, it becomes a judgment of the High Court where a white paper is issued within 6 months. So where that white paper is issued, then it shall become a judgment of the High Court. Where the report is not issued, but then upon the expiration of 6 months, same is also deemed to be a judgment of the High Court. Now, because commissions of inquiries are bodies charged to inquire facts, persons who appear before a commission of inquiry only appear as witnesses and not as accused persons. Again, persons who appear before a commission of inquiry appear as witnesses and not as accused persons. So usually, over the years, the Attorney General has sought to use evidence obtained at the commission of inquiry as basis to initiate criminal prosecution against them. And then the cases of Republic and then Republic versus Kajumpianing and Hakugobi have been clear on this issue. That persons who appear before a commission of inquiry only appear as witnesses. Thus, any evidence obtained forthwith may not be used as basis to initiate criminal prosecution against them. And again, findings of a commission of inquiry are deemed to be judgments of the High Court. So, if any adverse finding, usually where any adverse findings are made against any person by commission of inquiry, it is for those persons to rather appeal against those adverse findings, because those adverse findings themselves have some effects. So, if any adverse finding has been made against you by a commission of inquiry or anyone by a commission of inquiry, if that person is desirous of occupying or vying for the position of an MP, until upon the expiration of 10 years or more, that person cannot place himself up to be selected for or to be elected as an MP. If you are desirous of becoming a president, you are perpetually barred where a commission of inquiry has made adverse findings against you. So, yes, their findings have some consequences, but then the same cannot be used as basis to initiate criminal prosecution against anyone. So, Doc, I don't know if you may take over from here. Thank you.
I think there's Mr. Bill. Before I allow the rest to come, I think there's a follow-up question. I don't know if it's been addressed. That they're referencing the issue of commission of inquiry. Does the findings of the commission provide immunity for those who testify? Will it be far-fetched to think it's a system to free guilty people? The question is,
can I get a question?
Yeah, the question is in the chat. If you click the one CEO that have you seen it? Referencing.
I'm not reading, Doc.
Referencing the issue of the commission of inquiry. Does the findings of the commission of inquiry provide immunity for those who testify? Will it be far-fetched as a system to free guilty people?
Yeah, so in the case of the Republic versus Brokubobi and then Kodun PNE, the court by Justice Mafusan was expressed on the matter that if the issue is something that is criminal, the forum should rather be the courts and not a commission of inquiry. So persons who appear before a commission of inquiry, yes, there will be some criminal elements for which the commission may be inquiring into. So if the person appearing before the commission appears, he appears as a witness to help provide some facts to the commission, right? So usually, per the immunities provided under Article 2A3, once they appear as witnesses and then assist the commission with some information, those informations cannot be used as basis to issue criminal prosecution against them, because these commissions are rather inquisitorial and not accusatorial. So if the AG rather desires to prosecute them, the government should rather, first of all, not even set up commission of inquiries in the first place. They should rather use the normal courts. I don't know if I've answered it, though.
All right. Okay, thank you very much, Mr. Bill. I don't know if Mr. Ezekiel says that. Ezekiel, will you share some few thoughts?
But please, I logged out because of network. I just came in, so I didn't know where he got.
Okay, so the question is generally about the effect of the findings and recommendation of the Commission of Inquiry, and as whether witnesses that appear before Commission of Inquiry are immune from legal liability.
Oh, okay. So in my view, as Mr. Bill rightly said, when you appear before the Commission of Inquiry, you appear as a witness. Okay. So if we are to go by that analogy, then it means that just like any other, let's say even the normal practice of litigation, where somebody has been called as a witness, even if the case relates to yourself, any other person, it doesn't necessarily mean that if a liability has been found against you, you are immune from that particular liability. So I think, in my view, I think that in as much as you are here before the Commission of Inquiry as a witness, if there has been recommendations which implicate you in any of the findings that have been made by the Commission of Inquiry, then the necessary sanctions, be it civil or criminal, would have to follow. So, for instance, what happened in the OWUSU, you realize that if, let's say, upon the recommendation of the Commission of Inquiry, there has been certain individuals, of course, they made a lot of recommendations. There have been certain individuals who are implicated in such incident that happened during the by-elections at OWUSU. Then those individuals who were implicated would have to face the sanctions of the law, be it criminal or even civil, in that particular perspective. So I believe that, yes, you are a witness, but if on the recommendation you are implicated in any way, the law should take its course and then sanction you either civilly or criminally. So that's my thoughts on it, sir.
All right, thank you very much. And I think that in terms of the immunity and protection of the witnesses, it is also useful to remember the Witness Protection Act of 2018 at 975, right? If you look at the Witness Protection Act 2018 at 975, especially section 52, section then section and section 58, right? 52, 58. They all talk about the kind of protection which witnesses, including witnesses that appear before commissions of inquiry, are entitled to under the law. Okay, so thank you. So let's take another question. There are a number of questions in the chat. So We have to move very fast. I think this question has been addressed. Somebody has sent a question to the chat. He sent it to me directly. One button. The question is, the Supreme Court and High Court have concurrent jurisdiction in enforcement of fundamental human rights under the Constitution of Ghana. Discuss the veracity of the above statement with the aid of relevant authorities. I think we've discussed this question over and over again. And then when we met Sir Justice Dennis AGYEI, it was also discussed again. But because it has come up, panelists will give it like a quick go. Yes, when it comes to enforcement of fundamental human rights, it is not necessarily the case. Let's put it in proper perspective, right? It's not the case that the Supreme Court has concurrent jurisdiction with the High Court. No. The High Court still has got the exclusive original jurisdiction with the enforcement of fundamental human rights, except that where some fundamental human rights, for example, become a matter of constitutional interpretation, so much so that it is not just the interest of the particular citizen, right? Whose it's not just a particular citizen whose rights or just interests are just being violated, but depending upon the interpretation which is given, is going to also affect, if you like, the general public, so to speak. Then, despite the fact that it falls within, let's say, the Chapter 5 of the Constitution, which ordinarily speaking should have been within the exclusive original jurisdiction of the High Court with respect to the enforcement. If we look at the Ampofo AGYEI type of case, then the Supreme Court will be able to interpret and just interpret such a provision, despite the fact that it falls ordinarily within the fundamental human rights. So don't let us forget that when it comes to interpretation of the Constitution, the Supreme Court has the original jurisdiction, although the Makankan authority, as we have discussed, and it's a recent clarification are there, but ultimately the Supreme Court has original jurisdiction for the enforcement of fundamental human, or the interpretation of the Constitution. And if a provision of the Constitution, even relating to fundamental human rights, for example, will fall to be like interpreted, then the Supreme Court will be able to interpret it, and that is a unique case. But where there is no interpretive issue necessarily, and then you just need for the court to enforce your rights, right, within context of a certain given fact, then that falls properly within the High Court jurisdiction. Remember the Odla case against Attorney General, where the court made these points quite clear. And of course, there's another type of cases and all that. But I will invite my colleagues to also add their thoughts to that. And we just abandon this question to another one, because then we've discussed it extensively in some of the earlier lectures which we did, and the recordings are also available, especially when the Justice Dennis, the Justice of the Court of Appeal, came, I think, about 3 or 4 days ago. Yes, so I take your thoughts. Mr. Jamfi, are you there? Okay, Mr. Jamfi is not there. Now, AMORKO, are you there? I think she's not there. Oh, yeah, she's here. Good. Yeah.
All right, I can now speak.
Yes.
Yes, sorry, I have to leave my device for a while. I'm just returning. Doc, I think you have really said it all, that it's not really the case that the Supreme Court and the High Court has concurrent jurisdiction when it comes to enforcement of fundamental human rights. And I think this is something that our friends are well aware of. I have had opportunity to join classes where it was being discussed. So respectfully, I would have wished that we should pay attention to other questions that may have come in the chat box instead of overflogging this.
Okay, thank you. Ezekiel, 1 minute. You want to discuss this question?
No, sir, you said everything. Yes.
Okay, then let's move on to, there are so many other questions they have sent. Maybe there's this question from somebody said, I don't know whether he had a dream and then his ancestors or anybody, just as people get the dream about little numbers, that he should look at this question, this tutorial question. So the person sent it to me, and the person has sent it about 3 or 4 times at different times to me. And he or she, I don't know whether it's he or she, is insisting and pleading that we discuss this question from Wisconsin. So as I have told them in previous sessions, that as far as I'm concerned, when it comes to preparation towards the Ghana School of Law Entrance Examination, no question is useless and no question should be ignored. And the author of the question too is not important. What is important is that it falls within the 6 examinable subjects. So once it falls within that, then it is worth taking our time. So within that context, I think that let us all look at this question, which has come from Wisconsin College. And then somebody sent it to one of their tutorial questions. And I don't know why the person definitely wants us to discuss it. So let's discuss it, because if you don't discuss it, and tomorrow you go and there's a similar question on it, you will not pardon us for the rest of his life that we didn't discuss this question. So I don't know, Lawyer Gertrude, Mr. Ezekiel, Mr. Bill, I don't know if you're all here. Okay, Ezekiel is here. Lawyer Gertrude is gone. Mr. Bill too is not there. So I'm here with just Mr. Jemfi. Let me see. Mr. Jemfi. Mr. Jemfi. Yeah, TK. I think it's a different Jemfi. Yeah. Okay, so Mr. Ezekiel, OSEI?
OSEI.
Good. Can you see the screen?
Not too clear, sir.
Oh, right. But this is, okay, I'll just say the question and then we quickly discuss that. Somebody, one of the students sent it to me. Shapers Limited owns a chain of sports fitness centers, and it places an advertisement on its website on 5th January, which reads as follows, quote, pay for 1 year's membership at any Shapers Fitness Center and swim 400 consecutive lengths in any of our pools by 10th January, and you'll be rewarded with a free 1-year membership for you and your spouse. Happy swimming and good luck. Because of bad publicity arising from some of his new customers suffering heart attacks in their swimming pools, on the morning of 8 January, Shapers placed a highly conspicuous notice on its website withdrawing the promotional membership campaign contained on its website. With reference to case law and any other legal authority, discuss the legal position of the parties in the following separate scenarios. A, Andrew paid for a year's membership at his local Shapers Fitness Center on 7 January. The following day, he logged on to the Shapers website and read the revocation. However, he tried to swim 400 lengths that afternoon, but found that he did not have the stamina to complete more than 10 lengths. Hello. Then B, Bernice applied for a year's membership on the morning of 10th January, while arranging for payment of a membership fee by Visa card. She was informed of Shapers' promotion. As Bernice was a long-distance Olympic swimmer, she immediately rushed into the changing room to prepare for the challenge. However, Just before entering the pool, she was told of Shepard's revocation by a pool attendant. C. Kathy received a free membership at Shepard's Fitness Center in her town on 6th January. Having won a competition run by her church, she successfully swam 400 lengths, which was reported on local television, but Shepard subsequently refused free membership for her spouse as she had not paid for her own membership. So this is a question that one of you actually sent to us. Well, because we don't have the luxury of time, Ezekiel, I think that we should give like the guideline, right, regarding how you should go about problem-based question. We have said it before and we wish to reiterate again that if you have a problem-based question, you have to stick to the hierarchy. That means that you must have a clear introduction in which you tell us about the area of law, right? And I just added a suggestion not too long ago that having regard to the type of examination which you are doing, in which says law subject areas are being examined in one paper. And sometimes the question which come somehow, if you like, colorless in the sense that it does not immediately have the completion of any of the six subject areas. So therefore, you need to be strategic to also assist your examiner to know that you have clarity in your mind. So look at this question, for example, discuss the legal position of the parties in the following separate scenarios. It's a legal position. We've not been told whether it is contracts or torts, but of course, this one is a tutorial question, right? And as you see from the heading, it's really about formation of contracts, so you are assisted. So in the area of law, it will not be out of place if you said that the area of law is law of contract, particularly, let's say, formation of contracts, or often acceptance, as it were. Then, as still part of the introduction, you need to identify the legal issues, right? You need to identify the legal issues, and then when you are done, you have to take the various issues one after the other, state the legal principles. So the legal principles and the corresponding authorities, case law and other authorities. You do all that. When you are done, you then begin to analyze, right? Analyze and apply the principle to the portion of the facts and answer that particular issue or question. So then you've concluded on that. Then you move on and do the same thing for other issues and then draw your big conclusion. So that is the general approach which you should follow in doing a problem-based question. However, if you have what we call like the sequencing question, like we have, that you have some kind of like a general preamble of a certain background, and then you have like the a mini scenario which is forming like the stem of the question, so to speak. The number of ways in which that may be done. For me, to be simple and have a well-structured answer, I will stick to the traditional hierarchy. So that let's say that I will take A, right? I will take A, for example, and I will treat A on its own. Then I'll take B and take C and do the same thing. So that is one way. Or if you have this whole as one question, you could, for example, decide to raise all the issues together, and then state the law, and then when you are done with everything, you come and take each of the A, B, C, D, and then we deal with them. But I think that the first approach ensures some neatness rather than trying to use a shortcut, right? Okay, so these are my initial thoughts. Mr. Ezekiel, I will come to you now.
I think it's the same thing that I was also going to say. Says to add that, the markers are marking a lot of scripts. So any question that you would want to tackle, be it in the form of this or that, as Dr. rightly said, for there to see the point that you're making, it's better you treat each one of them separately, so that you don't make the work so convoluted, said that they wouldn't be able to know the point that you are trying to put across and all that. But aside that, the general means of doing the IRAC that you know, I believe most of you have been doing it and you know what goes into it and all that. Yes, even sometimes, I remember last year what I did, for instance, with the question of capacity, what I did was that, because sometimes I know that I wouldn't really have the time to write as I want to write. So if I pick an issue right from the beginning, I tell the lecturer or the marker the conclusion that I'm going to draw on that particular issue before I even begin to do the discussion on the law. But I know that wasn't the right way, but that is what I did, just to, from the beginning, letting the lecturer know that, okay, with this issue, this is the conclusion that the person is drawing. Sometimes, if they realize that right from the beginning, you are giving them, or you are giving an impression or a sense of what they really want in the marking scheme, it will go in a long way to favor you in terms of the marking and all that. And other times, if you decide to write and talk plenty without hitting it on the lane and all that, then that one, you find yourself being in the fires of the marker. So I will entreat you that in as much as you know the IRAC and all that, the law, state it as briefly as possible. Don't write break English, don't write long essays in the law. If the law is about offer, state the law on offer. The general principle is that for there to be a contract, there must be the correspondence of offer and acceptance. That's the general rule. Now you tell us, or you explain what you mean by offer, what you mean by acceptance. Very, very simple. Let there be coherency in terms of your writing. Once you do that, I believe that no examiner or no marker will reject your paper because of the fact that you are not able to communicate a clear thought of yours or something like that. And then I will also mention something about handwriting. Please, it's not something related to the question, though, but let me just say, handwriting is something that I believe that you would have to watch, because if you write all the knowledge that you know and your handwriting is not readable, then it is course 90. You've done a course 90 job. And this is not the faculty level where they will call you or search for your index number and your corresponding name, and then for them to come and ask you and give you some marks. No, this one, if they can't read what you are writing, they will give you 0, or at best on humanitarian grounds, you get something like 1 for wasting your ink or something like that. So in as much as you go by the stylish way of doing the IRAC and all that, I also entreat you that don't be pressured. Take your time, arrange what you want to write, and take your time and write. You are not expected to write like the artist or something, but at least whatever that you are writing should be very readable and clear for the examiner to see, so that they will know the marks to allocate you. So, Doc, that's what I will say with regards to the IRAC and everything that you said.
All right, thank you very much. Yeah, so one Rose has also sent a question. With the current COVID-19 pandemic, if a patient who has other medical conditions on admission at a hospital or in the care of a medical facility is infected at the hospital with the virus and dies as a result of complications from the infection, can the family bring an action in negligence against the hospital? Rose, I mean, despite the fact that has to do with the patient and COVID and all that, it is still essentially thought of negligence, right? So all the things that we have talked about, you have to be able to establish duty of care, breach of duty of care, and then the resultant damage, and especially causation. Causation becomes very important here, as to whether there was any break in the chain of causation and all that. So all the things that we have discussed previously concerning a thought of negligence are relevant. But here, you look at this and you notice that the other two aspects may not really be controverted, having regard to the circumstances, especially the existence of duty of care and probably the breach of it. But what may be controverted as to causation, as whether, for example, the death and all that emanated from the COVID, or because of the other underlying condition it sort of broke any chain of causation. And so those were the kind of thing which will have to be emphasized in a situation like that. Mr. Ezekiel is here. Yes, you have other thoughts in relation to that? Ezekiel.
Yes, Doc. So as you rightly said, yes, it's the general thing about negligence. And let me use this opportunity to say this about negligence. You know, sometimes, you know that we all know that when it comes to the element of negligence, they are basically in three, and then other books are the causation and all that. But you know the duty of care, you know the breach of duty, you also know the damage and then the causation element and all that. I would say that sometimes the question that, in fact, some of the past questions, even from the law school entrance exams, you realize that they don't really require you to do a discussion on all the three, because you realize that they are very broad and it is something on its own. So for me, I will advise that if you get a question and the question comes under the law, the tort of negligence, then just from the beginning, after giving the definition of tort and stating the element, you pinpoint to the examiner or the marker which particular element is reflective of the, what do you call, the fact that you have been given. Because they don't require you to do that broad discussion of all the elements. And most of the questions will be on a particular element of the tort. So for instance, I think somewhere in 4 years ago, there was a question about where a teacher sends some students to a trip. And when he sent the children to a trip, some of them got injured, a lot of things and all that. And before the teacher was even going to a trip, I think there were some warnings about the weather conditions and a whole lot of stuff like that. And now they were to ask to define, advise the teacher and then the student, the parent of the student and all that. This was not something that required students to do a whole discussion on the tort of negligence in the sense of discussing duty of care, discussing breach of duty, discussing damages, discussing the what do you call it, the element of causation. It was something that needed to test student knowledge on duty of care as an element of the tort. But you realize that in coming to do this particular discussion on the elements, which is the duty of care, you would have to give a mention of all the other elements before you focus on the particular one. So I would say that look at the question very well and look at the fact and ask yourself, does it reflect the element of breach of duty? Does it reflect the element of damages? Or does it reflect the element of causation? Or does it reflect the, what do you call it, the element of duty of care? Whichever one that you think it's reflective in the fact, that is what you focus and do the discussion on. Because to do a total discussion on negligence by going through each of the elements in seriatim, you wouldn't finish and you wouldn't have that luxury of time. So please pay attention to the fact. So that is what I would say in respect of negligence. Yes.
All right. Thank you very much, Mr. Ezekiel. Sir, Eunice Oforiata has this question, which she thinks has not been answered. What is that question? Please. My question is whether or not in an AMARH situation, we have to analyze the rules one after the other or together has not been answered. Kindly touch on it for me. Okay, so Eunice, if I understand you well, you want to find out if you have a problem-based question in which you should follow the AMARH. What do you do with the rules? You know, we have said that you take each issue, or if one or two issues are being treated together because of their inherent closeness, right, or interconnectedness, and they have to be dealt with, that is fine. Or if you are just doing one issue at a time, then you state the relevant law, the rules or the principles underneath. And at that stage, you are doing just the stating the principles with the corresponding authorities. When you are done, then you do the analysis. Doing the analysis simply means that now you've told us the law, you know the facts, right? So based upon the law that you have stated and looking at the facts, how will you resolve that issue? The issue is supposed to be a legal question. How will you answer it? If, for example, we say that whether something constitutes like a valid offer, you have told us what a valid offer is as established by the authorities and all that. Now you go back to the facts. if you look at what happened and then you juxtapose that by the principles that you have stated, will you answer the question as to yes, that is an offer or that is not an offer? So that is the crux of the matter. Okay. Yeah, so I think that you have to use that for all the issues and then all the principles. Eunice, I don't know if I have answered you. Somebody is asking a question about the Anglican priest kissing the student. What is my opinion? And what has that, I mean, if an Anglican priest kisses a student, what has that got? Oh, you mean like the legal implications? Of course, if you are to analyze it, we have to start from a number of perspectives. Maybe from the perspective of like the law of tort, assault and battery isn't, I mean, battery and assault, like certainly a battery, but you have to know that if consent was lacking, then you'll be able to establish battery as it were, isn't it? Or you come to, I mean, I'm still in the area of tort before we come to criminal law. If you come to the area of tort too, can we say that the Anglican priest, if for example, is the chaplain of the school, the school and the chaplain, the teachers, they all stand in, if you like, in the position of the in loco parentis, like they are supposed, as it were in the eyes of the law, as parents to the children. So they owe the children, and of course, their parents a duty of care, isn't it? To ensure that they are safeguarded and they are not exposed to bad morals and other things and so on. I mean, just being very creative in how we think or reason with the law. So that is what I'm trying to do. I'm not saying that anything is settled in that respect. Then we come to criminal law. Yes, some of you, FJ has already indicated that indecent assault. Indecent assault, what is the test of indecent assault? Of course, kissing, lips to lips kissing, isn't it? Lips to lips kissing. Yeah, so Daniel, I don't know whether my thoughts have actually responded to some of the things that you have in mind. But Daniel, I can see that you have a very curious mind. When you have few hours to the exams, thinking of the Anglican priest kissing the student. Okay, let me see. I don't know, are there other questions we have in on the rest? I think we are done. We should be winding up. No, contract or not actually. I think that we're going too far. Somebody is trying to find out whether we can get the contractual implication from the Anglican priest who kissed the student. Ezekiel, I don't think contract is relevant. We'll be going too far, isn't it? What do you think?
So contract doesn't come here, so it doesn't. It doesn't.
Very well. Yeah, so I think, I don't know, I think we've exhausted the questions, so we should be winding up.
Yes. No, someone was saying if we could throw a light on the, what do you call it, bail.
Okay, so please have a go.
Oh, right. Yes, sir. All right.
But let me find out.
So first of all,
are they there? Because it's like with only you and me. Mr. B, are you there? No, he's missing. Okay, you're not online. Miss, are you in the Zoom? Oh, right. Take it. Oh, very well. You are co-host, so you can unmute yourself at any time. Yeah.
Okay, it's me. I'm muted.
Okay, so the question about bail. Can you share some thoughts on bail? And then Ezekiel will come in. Take it.
Bail.
Yes.
Bail essentially is a function of flight risk and danger to society. so that what the court will consider is whether or not the accused person or the suspect who is in custody will appear to stand trial. In that regard, Section 96, Article 19, and the Martin Pebu cases are very relevant in that direction. So that if you analyze from the fact pattern, if you analyze and you realize that considering the status of the accused person, let's say he has a fixed place of abode in a community, he is well known, he is employed, he has children, he has a wife, then you know that yes, the accused person, he or she, is not a flight risk because he has strong ties to the community in which he or she lives. So that if the fact pattern evinces such a scenario, then in effect, you can conclude that yes, if bail is granted to this accused person, having regard to the facts about his occupation, place of abode, his marital status, and all that, his children and all that, the person will not evade the person will not evade trial, or the person will not run away, then in that instance, the court will grant bail. I have a situation tomorrow where the lady has been in custody from October last year. She's been charged with abetment of murder, to wit, abetment of crime to wit murder. She was staying with a house girl, and one time she accused the house girl of stealing her money. So, and she operates a beer bar. So the patrons who were at the beer bar, when she complained to them, they beat the lady to pulp, and as a result, she died. The house girl died. And this lady, the woman, was arrested together with one of the accused persons. 2 are on the run. And she's been in custody, as I said, from October. We made an application to the district magistrate court. It was refused. So we've repeated the application in the High Court. And tomorrow, this is essentially the arguments we are going to put across, because having regard to the facts pattern, this woman lives in Santase. She has a fixed place of abode. She has 3 kids. She's married, but more like a single parent because the man is not around. So the man doesn't even come to court. He doesn't. So the children are now staying with somebody. So all that we need to prove to the court, yes, it's a serious offense anyway, but having regard to the ties that the woman has in the community in which she lives, we don't think that she will evade bail. She'll run away from trial when she's granted bail. So those are the facts that the court will look out for, whether or not to grant bail. And now from the Martin Pebu case, irrespective of the crime, the court can grant bail. The court can grant bail. And if you are looking at that, Justice Sophia Kufu, no, it's not Sophia Kufu, one of, I've forgotten his name, AGYEI, he dissects the issue of bail in Republic versus Gorman. He does it very well, especially when you look at the sections 96, 1, 2, 3, 4. He takes them one after the other. And he makes very, very erudite discussions on them. So you can have a look at a feel of that, just, a quick brush up before you go. And before I end, if let's assume that you have a general question, because now you are not, you don't know whether or not they'll ask a non-law question, as we had, because at our time we had a non-law question which was on corruption, and it was an essay. Now when you are writing an essay, for us it was on corruption. You have to give a general introduction on corruption, so that your introduction must capture what is called a thesis statement. The thesis statement in effect gives an outline of what the essay will talk about, so that a cursory reader, because anytime the first thing that the person reads is your introduction. If the person reads your introduction and the introduction gives guidelines as to what is going to be discussed in the subsequent paragraphs, it helps the reader to follow your discussion. So that, let's say you have corruption, you can go by a definition of corruption. You can go by an anecdote, a short story about corruption, just like 5 or 10 lines. in the introductory paragraph, and you link it to the topic. So when you are done with that introduction, you say, like, in this essay, I will discuss the causes and effects of corruption in the country. So that is what is called the thesis statement. In this essay or in this write-up, I will discuss, or the causes and effects of corruption will be discussed in the subsequent paragraphs. That is, you have indicated to the examiner what you are going to discuss subsequently. So after the introductory paragraph, you come now to the first paragraph of the body. So you go like, first and foremost, then you discuss. When you finish, secondly, thirdly, there should be transitional markers. When you are ending, you, in conclusion, in sum, suffice it to say, at least it will give the examiner a guideline as to how your essay has been arranged. And it helps the examiner to understand the points that you have raised. Because when you're moving from one paragraph to the other, there should be that transitional marker. So that, because you took the first one, first and foremost, or firstly, you come to secondly, thirdly, furthermore, also, you should arrange it. And every paragraph should be distinct, and it should talk about a distinct idea. So that you start with your topic sentence, and all that you say in the subsequent sentences must be relevant to the topic sentence that you give. So that is it about essay questions that are non-law related. So you have to give a very beautiful introduction about whatever it is. You can use statistics. It's essay. It's essay. So your facts necessarily must not be accurate or anything. But you can, like, if you're talking about corruption, what are the institutions that are responsible for combating corruption? Like you can talk about the Integrity Initiative, all those. So let's say in 2016, the Integrity Initiative indicated that Ghana is suffering under the weight of corruption. The UN, you have to go systematically for the person to know that, yes, it's a problem that we need to, if you like, counter. So your introductory paragraph should be so much, it should carry so much information, and it should provide an idea of what you are going to do in the subsequent paragraphs. So your transitional markers, as I said, firstly, secondly, furthermore, third, you can go by that order. In conclusion, in sum, to conclude, then you conclude beautifully. Doc.
Thank you very much, Mr. Stanley TWENEBOAH KODUA Jemfi. I think that we are going to draw the curtain down, and just to reiterate some of the things I will be discussing already. My panelists have done a very good job trying to touch on a lot of things, but I noticed that one Awin Nama's hand has been up for quite some time. So let us allow, yes, Awin Nam. Are you there? Yeah, please, let's hear you. Okay, the person is not paying attention. Yeah, you can mute yourself. The person is not paying attention, just by accident. Okay. Good. Yeah, so Phyllis Akoria. Phyllis, unmute yourself. Yeah. Phyllis, unmute yourself.
Hello, Doc, can you hear me?
Phyllis, I can hear you.
Okay, I want just a few clarifications on what our brother has just elucidated so beautifully, that when it comes to bail, it is all about whether the person is a flight risk or whatever, looking the circumstances as to the family that the person raised. Is it not also the case that the cause in considering bail, you will look at the nature of the offense, the evidence in support of the charge the person is facing, and as to whether he has those people who are for lack of any better word, wealthy to do. Those people who have good character, fixed place of abode, sufficient means, and all those kind of things. Will the court not also consider all these factors before granting bail?
No, you see, we have what we call the conditions, right? We have to understand bail essentially as a contract. A bail is like a formal contract between you and the state. And that is why there's something called the estrangement of like a bail bond, right? And if you remember the history of contract, penal bonds and all that. So, so you are admitting the person to bail. That can be made subject to conditions, or what they call like sometimes we provide what they call like the surety to justify. All the things that you mentioned, they are meant to establish, as you rightly said, as whether the person is likely to run away, whether it's a flight risk, whether it's likely to bolt away, and things like that. So that is what makes it necessary for these things to be, but they are not determinative of whether a bail is supposed to be granted or not supposed to be granted. As we know, our constitution and Mr. Jemfi made it quite clear that the Martin Pebbles cases clarifying the position in Republic versus government in relation to Section 96-98 of the Acted, the Criminal Procedure Code, which previously had created the impression that if you like, as if certain type of offenses are bailable and some offenses are not bailable. The position of the law is that no offense is non-bailable. Every offense is bailable. But then what is important is that having regard to the circumstances. Let's say that the crime, right, is said that if the accused person is released immediately, it's going to affect investigation in a very serious way. And for that matter, if the state can make a case to the court could, for example, say that due to XYZ, bail should not be granted or something like that. But it's not, I think, that conclusive of the matter. Mr. Jemfi, yes, you want to come in? All right, thank you very much. Yeah, so I think that we would like to end our class here. Just to reiterate that with respect to the multiple choice questions, I always talk about the elimination approach, which simply means that first and foremost, if you get the question, the multiple choice, read it quite well, right? Make sure that you read it well. Pay attention to every word, because multiple choice are quite tricky. If you don't pay attention to every word, despite the fact that you may very well know the question, you get the answer wrong because you ignored not, right? Which had changed the meaning of what the examiner is actually trying to do. So please pay attention to every word. And secondly, when you are given options A to D, right, or A to E, you've read the question, you read A, and as soon as you read A, you think that A is the correct answer. Please don't rush to choose that and then say that you have the answer. Test the correctness of A, which you think is the answer, against the remaining other options, right? So still go through the other options and use the elimination method to cross the other options out, so that you become very sure that the one you have settled is really the answer, okay? And secondly, too, when the multiple choice are not many. So one practical advice is that, as let's say that you start from question 1, once you have really settled on the answer and then you are sure that you have the answer, you shade on the scannable sheets. Now you can do a circle around question 1 to let you know that you have fully answered question 1. Maybe you go to question 2. You're not too sure about the answer, so you don't want to be detained by question 2. You need to move on to other questions. So don't circle question 2. Move on to question 3. You get to question 3, you're able to get like the final answer, and then you shade on the scannable sheet. Fine, you made a circle around it, that order. Now, when you are done with everything, okay, then you come back to those questions which you left unanswered, so that we come and juggle again to get the correct answer, as it were. So that is how you should go about that. And some of you asked me whether we meet again tonight. In terms of our extensive discussion, I think this is the last one. In the evening, maybe 30 minutes, I'll be on the either YouTube live or something. And if you have like, please, I've noted that some of you are just recycling the same question. All the questions which came, I can say that 98% have been dealt with ever since we started this revision, either with myself or with other invited guest lectures. And yet we keep bringing them up. So when I come online in the night for about 30 minutes or 40 minutes, I want you to bring up genuine, problems. Like if I say genuine problems, things which are really bothering you, and not things that you can easily get the answer or you've done, okay? So let's pay attention to that. So I will invite my other colleagues to give their closing remarks, and then we go. Mr. Bio, are you there? Kathy is not there. Mr. EZEKIEL, you have any closing remarks?
All right, Doc. So as we already said, they should believe in themselves and they shouldn't forget to pray. And I believe that by the grace of God, they will sail through this successfully. Yeah.
Great. Thank you very much. Thank you very much.
Prof.
Yes.
Yes, one last question. I'd like to find out, in answering a problem question, is it advisable to write the issue, then underline, then write the analysis, then underline, then write the
right. Okay. Right. Thank you very much. Yeah. In Ghana, right, just speaking in relation to our country, and based upon what I've observed in the legal academy in Ghana, we have what we call the varied practices. Personally, I don't like that, and I like the practice in most of the UK schools where they don't write that. But I've noticed that increasingly in Ghana, a good number of our senior police and even they do that. So if you did that, it's not anything wrong, right? Because we don't have like a settled consensus as to the uniform approach. So in this type of exams, since we don't have like the official chief examiner's report, which is issued for consumption of students, I think that you'll not be penalized if you did that. But if you didn't do that and you also just did it like the way that I also prefer, you also not be penalized. The most important thing is that you're following IRAC. The introduction, you have your statement, the area of law, the identification of the issues, and then you come and take the issue one after the other, and then you take the issue, you make it like the subheading, or you underline it or whatever, and then underneath, you outline your principles and the corresponding authorities, and then you start the analysis and application, you draw conclusion thereon. You move on to another issue and you do the same thing. When you've exhausted looking at all the issues, then you come to draw the big conclusion. And then whatever advice that we are supposed to do, then you do it there and then. Okay, so Awima, so that is what I can say with respect to your question. Yes, I think Mr. Bio and then Mr. Jemfi, you give your closing thoughts and then we are done. All right, thank you, Mr. Jamfi. Mr. Bio, anything? Okay, so Mr. Bio is not there. So I think that not all of you probably be able to join me for the 30 minutes online at I would like to do it early. I'd like it to be strictly exactly 9 p.m. so that by 30 minutes we can finish. I'd like you to have enough sleep, right? Please.
Oh, did you hear me?
Don't stay overnight. Okay. So try and go to bed early. Get enough sleep. And that is why I'm not going to have. Yes, I've come to you, Mr. Jamfi. That's why I'm not going to have extended session tonight, just 30 minutes, so that you can go to bed. Yes, Mr. Jamfi, you have to repeat.
Unfortunately, I was on mute.
Yes, please.
Okay, so what I was saying essentially is that, guys, do not panic. Go into the exam, have the mentality of a winner. And I assure you, this will be your year, because we all had to go through this same procedure. And do not, and again, do not think that they've deliberately set traps to make you fail. No, nobody has done that, and nobody can have any means through the law school other than to write this exam. And when you pass, you pass. Nobody can take your pass away from you. So it's a competitive exam. So what you have to do is you have to distinguish.
Mr. Bio, please unmute yourself. Mr. Bio, unmute yourself. I'm sorry.
Your principles must be well set out, and your application. So in applying the above principles to the instant case or the instant matter, so that at least you have to make sure that everything is on point. Paragraphs should come, your conclusion, everything. So I pray that God be with you. Do not panic. He will take you through at the end of it, or you come and join us at the bar for us to have fruitful discussion going forward. Thank you very much, Doc.
Right, thank you. I think before we meet at 9, as a Catholic, I'll try and say my Holy Rosary for you. So have a very good afternoon. May the Virgin Mary, seat of wisdom, intercede for all of you, so that the Holy Spirit will help you to be successful. All right, thank you very much for being with us.
God bless you, Doc.